Okay, so we know what the topic of the day is, and we know what potential solutions there are. And I think many of you got examples from your own country that you would have mentioned during the sessions if we'd have had a Q&A straight after those sessions. So we're going to have 4 roving mics. If you want to ask a question, raise your hand. I'll try and be fair where I choose people. And wait for the microphone. Tell us your name and your organisation, and then ask your question. Keep it brief, please, and and all the panellists, I think, from today are here. So if you want to address a question to a particular panellist, that's fine. If you want to make a general point, that's also fine, and we'll maybe follow them up. So I think we're ready to start. Just look at Dinos, yes? Okay. Who's got the first question? Yes, please. Thank you.
Okay, more than a question, we have discussed today about the remuneration right, which is established in Spain, the equitable remuneration right. And I was just to point out first some data. Christophe said in the precedent panel that the distributions started in 2019. But in fact, this was, the most important part of the distribution, of course, started because we had more agreements with the platforms in 2019. But the right was incorporated in the Spanish law in 2006. This right, we started to have some agreements, and we started to distribute the right in 2012 for rights collected in 2010 and 2011. So this was, but we had at the same time to sue the platforms, certain platforms, and to continue negotiations. The right is at the present is a stable right. Distributions take place every year. They are increasing, and this right is based, as Dinos has explained at the beginning, on an equitable remuneration which is collectively managed when the right is transferred to the producer, and there is a presumption of transfer. Which is also important to know about this right is that is an international solution. Even if it is collected in Spain from the platforms directly negotiated by AIE with the streaming platforms and everyone that make available the subject matter of performers. It is distributed internationally through bilateral agreements, and it reaches both main performers and session musicians. Which supposes that every performer is covered by that, and every international performer is also covered, because we are applying national treatment, not reciprocity. And that's it, I think. It's the basis of the regulation.
Thank you, Paloma. Thank you for that clarification. Just maybe this is an unfair question, but can you remember what that generated, how much that generated in the last year?
Okay. I have to check my figures.
Okay, let us know maybe tomorrow. It's interesting. People will be very interested in that. Thank you for that clarification on that. Next question, please. Horace.
Okay, I'm going to be a bit cheeky here. We have tried to get the rights owners, the record labels, to come to the table and negotiate what we would think would be a fairer package for performers out of streaming. And I do think that the rights owners hold the secret to this. We haven't been successful. Over many years now, they have batted it back and said they are. Larry did a good job this morning explaining how they are paying out more money than they ever were before, etc., etc. But we all know that, the session musicians are getting nothing from streaming, and an awful lot of featured artists aren't getting a fair share. So how do we get the record labels to come to the table and negotiate? Well, I think the only way to do that is to put pressure on them. And how do we put pressure on them? Because, again, we know we don't have a very strong hand in negotiating with the labels. There has always been a clause in recording contracts called the third-party license. Even when I signed a record deal, as you heard me say earlier, back in the 70s, there was a clause that said, if the record label licenses the recordings to a third party, then whatever they receive, they split 50-50 with the artist. So the third-party licensing has always existed, it's always worked, it's always run. But of course, it was there because it wasn't the main way the record label made its money out of the artist. The main way the record label made its money out of the artist was by selling directly, not through a third party. So the third-party license arrangement worked very well. I would contend, and I think I'm pretty sure in saying some artists have already gone to court on this, that licensing the recordings to a streaming platform is a third-party license. And as such, it should be 50-50, split with the artist. The money that the record label receives from the streaming platform should be split down the middle with the artist under the terms of a third-party license. Now, as I mentioned just now, I think there are some artists who have actually challenged this in court, but they've always settled outside of court, and therefore no precedent has ever been set in law. I know full well, and I understand, that record labels cannot continue with their business model, cannot survive if they have to pay 50% of what they receive from streaming platforms over to artists. They simply can't. The business model isn't sustainable. They won't invest in new music. They won't be able to pay their enormous salaries. They won't be able to do all the things that they do. So if there was a class action where a number of artists were to group together and take a label to court on the basis that the streaming income is under a third-party license, well, the court doesn't consider whether or not the record label can afford it or not. The court considers whether or not it's justified in upholding the claim that it is a third-party license. This, I think, would make the record labels sit up and sit down with us and negotiate what we think would be a fairer deal. A deal that would mean that they could continue to do what they do, but the artists would get a much fairer share, and some of that money would go to session musicians. It's just an idea. I know there'll be a lot of people in the room who won't like it, but I think we've got to try and move this debate forward.
Thank you, Horace. I'm not going to ask Larry to respond because I know what the response would be, but let's leave that with the representatives of the musicians here and see what happens. Naomi, I saw your hand there.
Thank you. So I'm General Secretary of the British Musicians Union. I just thought I'd comment on the UK situation because it's come up a few times today, and just to clarify where we got to. So we had the streaming inquiry, which was a government committee inquiry into the economics of music streaming. This led to a lengthy process where we had a transparency code and a metadata code signed by the industry, and then a process looking at creator remuneration. We believed that the government's pressure on the record labels would perhaps bring forward some solutions, and the government was very clear that they wanted to look at voluntary solutions. What was eventually announced by the record labels in the UK, the BPI representing the major record labels and some of the independents, they announced a package with the government which was per diems for songwriters attending studio sessions, the upfront session fee increasing, which actually we'd negotiated and balloted our members on at the end of last year. So that was a collective bargaining process that was taking place anyway. We do welcome the upfront session fee going up, but we don't believe that that is fair and proportionate remuneration for session musicians for music streaming, particularly if tracks are really successful. And the other thing that the major labels announced was packages for artists, particularly legacy artists, to boost streams. So really talking about promoting legacy artists and helping them to attract more streams of their tracks. But the problem with that is if they're on a very low royalty rate, then they can have more streams, but that will benefit the record label, it won't benefit the artist. So what we wanted was for featured artists to have a modern digital royalty rate that was applied on all old contracts. We didn't get that. So ultimately, as Horace says, you know, we're in a position now where we're going for legislation, but I think we've got to use all the levers that we have available to us. It's clear that a voluntary solution is not going to be forthcoming in the UK. And, you know, as we talked about, the lack of bargaining power, because our members can't withdraw their labour, makes it very difficult. I mean, it is possible that our members would agree to stop doing sessions, but it's very challenging for freelance musicians, as we know. So it's hard for a union to take that kind of course of action. So I think we do have to consider legislation, and also we definitely have to look at lawsuits as well.
Thanks, Naomi. It would be very difficult to take any sort of action. The AFM did it in the 1940s, I think, Tino, and that was successful, but times have changed. Times have changed in every country. Roberto, thank you.
Thank you. Roberto Melo from Abramos, Brazil. The two panels showed clearly, very clear, the difference between the copyright system and the author rights system. While the copyright is determined by the work or by the track, the author rights, le droit d'auteur, is completely different. The view, the point of view, the center of the right are the persons. That's the reason because I always says that for us, author rights system is easier to find a solution. For example, for reproduction rights, for streaming, for artificial intelligence, than to copies that adopt a regime of copyright. And another question I believe that we need to point out that the partition of neighboring rights, relative rights in Brazil, for public executions, performers have 41.7%, producers 41.7%, and non-featuring artists 16.6%. I believe is an advantage to the musicians and to the performers to show that they are the major beneficiaries of the whole system.
Thank you very much for that. That's a very interesting statistic. Yes, please. Thank you.
Hello, good evening everyone. This is Sanjay from India. I represent the Musician Federation of India. I'm Executive Director. I'd like to ask to the forum that what we can leverage, what is working well currently, rather than crying over spilt milk or fixing what is broken. So if you can focus on that and give me some pointers how we can leverage what is working well.
That is a good question. We've already heard about what's happening in Spain, and we think, certainly from the performer's point of view, we think that's quite a good system. We think it's a fair system. Maybe I'll ask Lowry to see what he thinks of the Spanish system, if that's fair to all sides of the industry. But that's the model that we've been looking for. It's worth investigating what happens there. Speak to Paloma, she'll help you. Otherwise, we're waiting to see what happens with prospective legislation in Belgium. That's now, as you heard, with the EU Court of Justice. We'll see what happens with that. Various other solutions around the world. But at the moment, the performers' organisation is sort of coalescing around having the Spanish method of dealing with streaming through an equitable remuneration applied elsewhere. Maybe it's not perfect, but we'll see. But it's interesting because, remember, this is a right that's divided between the record producers and the performers. It's not just the performer's right. So we need to do this in tandem with our colleagues in the phonogram industry. Can we have the microphone at the front, please, for Lowry?
Thank you, John, for giving me the opportunity. I think it's fair to say to express maybe a different view on the ARR. And let's be first fair on the Spanish system. It actually is not split. It is a right that is granted only to performers. So it is different from the equitable rights system that we see, for instance, in the Rome Convention that is applied to communication to public and broadcasting more generally, which, by the way, is a massive value destroyer if you look at what broadcasters pay and what streamers pay. But that's another discussion related to the fact that we need to fight for the value of music. Let me get back to the Spanish system. and why we believe it is not a good idea. And there are a couple of sort of fundamental issues. And as I think I already said, our fundamental first point is that it ultimately undercuts the value of the exclusive rights, both performers and the labels' exclusive rights. And the reason is that the end user will now have to buy two rights packages, which means that the license that the labels will pay will grant to the streamers, which includes obviously the rights that the artists have transferred to the label, will be of less value because part of what the streamers we need to obtain will be paid to the CMOs, ultimately to the performers. The second point is that as far as we can see, the CMOs do not have, at least not currently, the kind of systems that are required to process the billions of lines of usage. So the question is it sensible for every CMO on earth to invest in systems that will allow them to handle these national additional rights to remuneration? And the third point is, we still believe that the free market licensing based on exclusive rights, both the artist rights that they license or transfer or not to the labels, and then labels on to the streamers, is the best way to ensure that fair value is transferred throughout the chain. And that includes the artist.
Thank you, Larry. You bring up a number of points there. Let me just clarify one thing about the value of the exclusive rights. If you talk to a lot of performers and their representatives, they'll say that the exclusive rights have been devalued because of the nature of the contracts, the nature of the transfer of the rights, the nature of control of the rights, and ultimate control of the recording. Of course, the rights that we gain through the Rome Convention and the WPPT are unwaivable. They're rights that the performers take with them. So they value them very much. And I know that you believe that undermines we've had this conversation before, the actual value of the exclusive rights. I think a lot of performers would disagree. They see that as tangible income. And some see it as considerable income. And that's non-featured as well as featured. So this is where we've got that kind of dichotomy. We've got to actually, square that circle, I think, to get that. But thank you for that clarification there. Laurent.
Okay, just to say, the value of rights, it's important, but we need transparency. And so at the moment, it's not okay for us because, in the European directive, we have the Article 19, and I'm not sure many countries had tried to enforce this right of transparency. And I think it's the moment to do that because there's a review of the directive next year. So it's very important. When we talk about value of rights, we need transparency. We need transparency of all the revenues that are generated by the exploitations of rights, of performers' rights. It's very important.
Thank you, Laurent. It is very important. Transparency is something we do need to talk about with the unions and the CMOs. Johan.
Thank you. I've been very gentle today, but if you touch upon my children, I lose that capacity. Value destroyer. I do not like the word value destroyer. Remuneration rights are value destroyers. No, it's like you said, they try to keep value. That was also the message I tried to bring across during our panel, that it's the actual objective to value. So no, they're not destroying value. Broadcasters, for instance, it's an exception to an exclusive right. So it is a difficult exercise. It is a difficult negotiation, but to compare that and then say, oh, if we get that money from streaming, that would destroy, well, we also do not get the same money from cable distributors as we get from broadcasters. So every user has a different tariff, and every tariff is negotiated based on the rights you have and based on the business they make with it. Because for me, the biggest value destroyer today is the contract of performance science with a record label in which his exclusive right is transferred. That's where a performer destroys the value of his exclusive right. So because CMOs, okay, we can call them unnecessary additional intermediaries, and it's just an additional cost, and it's only just to sustain the CMOs. They don't bring added value. But sorry, if you pay 1,000 euros through a CMO, 800 euros gets distributed to performers. We had the numbers. You need 17,000 euros passing through a record label to get the same amount of money. 17,000. So you need 17 times more money to go through a record label. So who is the big swallower of the value here? Sorry, it's not the CMOs. So that is the second point. And the last point is, I'm sorry, I do not accept the criticism that we're not up for this. I get it, there is some work to be done, and we need to do a lot of collaboration to make sure that the most pertinent of our organizations take the lead in doing this as a joint exercise. But looking around the environment of the record labels, I mean, you said it yourself, Laurie, that most of the value created by streaming these days goes through independent record labels. I know them. They're all small enterprises, and they're all not coping with the data. So I'm sorry, a French CMO like Adami has a very bigger capacity of treating data than the biggest independent record label in a country like Estonia or Belgium or Slovenia or even Italy. So no, we're all in the data business, and there is work to be done, but it's work that we all need to do. And I don't like the message of you're not up for this. We're all up for this. We just need a little bit more openness.
Thank you, Johan. I imagine Larry wants to respond for some of these, but let's collect a few of them. So I've got Irene first and then Paloma again. So Irene.
Hello, Irene from Costa Rica. I just was thinking in the great responsibility that we have as unions to communicate this to the youth. They're the growing audience of music streaming. The group of 24 to 35, the group of 16 to 24. And it's a generation that is natively digital. They're very self-aware, very justice, social aware. And this has to be communicated. We need to communicate this in our countries, in the youth of our countries. We don't have to underestimate the power, the generational power, and what they think. Look, what is happening, for example, in topics of climate change and other topics. They're very informed, and I think this should go out from our unions and also to the youth, to the general public, but especially the new generations. They are very aware, and I think it's an important topic for the future.
Thank you for that point. The unions have been very good at educating their own members about their rights and what they can do with them, and so the CMOs. But we haven't actually extended that education as far as our own bodies are concerned. And telling our public, I know that Johan said he didn't like the fandom thing, but the general public are going to listen to lots and lots of different kinds of music. They need to understand this to a marginal extent. So Paloma next, and then David.
Yes, regarding the criticisms to the Spanish system, for me it's not a matter of losing value. It's a question of distribution of the value. Performers shouldn't be the last ones in this distribution of what is collected. And of course, we have a certain amount collected for producers, for performers, and the part of the performer should be increased, because as it has been explained today, what is happening that performers, if they are so happy about how it is being paid, how they are being paid, why they are criticizing all of this all the time, the way it has been shaped. And as to the question of how CMOs can distribute this remuneration, it's not true that we don't have the means. We have, at first, we get the information from the services, from DRM services, and performer CMOs are grouped in platforms and are grouped in organizations. We have IPD system for the identification, VRDB in SCAPRA. We are all grouped in SCAPRA, and we have the information, the systems, and we have the data for the distribution. And we are in Spain doing it right now. I have checked the figures, and for the making available right, both phonograms and audiovisual, because in Spain performers also have rights on the audiovisual. We have distributed in 2024 more than 7 million euros. This is because of the collection and the possibility of distributing the rights.
Thank you, Paloma. Interesting you brought up data, and Johan brought up data too. It's Horace and I were at a meeting at PPL in the UK, the CMO there, for labels and performers, and we were both surprised to hear that there's been a difficulty in getting VRDB and RDX, which is the labels system of data, to speak to each other. And we found that rather strange. But I'll leave that hanging in the air. Maybe somebody would like to comment later. David, sorry, can we have the microphone just here, please?
Thank you. Just sort of following on, I wanted to pick up on there is a dichotomy here, and it is that if you have publicly listed rights holder companies and their job in respect of their rights holders is to make as much money right now as is humanly possible, that's diametrically opposed to building a business that is more long-term focused on creator remuneration and a more long-term artist-friendly business. Now, actually, Larry touched on this earlier. We are seeing the independent sector growing. In my 6 years in my role, the will to sign major record label contracts or large independent label contracts is diminishing. Artists are much more wary. So there is a dichotomy in that money today for rights holders, building our business for the long term thinking, and how record labels think about this. And I think that's really important right now. I think we in the UK, or I suppose in the UK, perhaps naively, we wanted to reach an industry-wide solution. We didn't want legislation. We wanted the industry to come together. And what we have done over the last 5 years has demonstrated that it is simply not possible because of that dichotomy, because of the money in today winning over a fairer long-term business model that fairly remunerates artists and other performers. But what we are seeing is that in the long term, I think that artists are going to want to sign. Well, firstly, there is a differentiation within the major labels. You look at the major labels, 2 of them are publicly listed, 1 of them is not. The one that is not publicly listed has gone the furthest on unrecouped balances. The 2 that are publicly listed have not followed suit and have not got as artist-friendly policies in place. So I think we are seeing that slow drift. But what we're also seeing at the same time is an approach of mergers and acquisitions ahead of signing new music and signing new artists, actually. We're seeing large record labels move into controlling the market, acquiring companies and controlling access to the market in order to shape the terms and conditions by which the rest of the sector has to operate. And I think that ultimately is where the problem lies. I think there is a dichotomy in publicly listed companies wanting money today versus companies that want to build long-term, artist-friendly, performer-friendly companies.
Thank you for that. Any other points? Yes, please.
My name is Ryszard Wojciula. I represent Polish Musician Union. I have one point I think is crucial to define the role that streaming plays today. The industry take the position that is a new type of publication, but is it all? From functional point of view, it's also a new way of broadcasting. When I drive the car, I listen to playlist, not record. In such cases, streaming has taken over the function of the radio. Why is this is important? It's obvious. Music performers are entitled to royalties from broadcasting. And maybe this is the way to fight for our rights.
Thank you, Richard. Thank you for that. Any other points? Oh, yes, at the back, Heather.
Not a question, but I just wanted to share a bit of breaking news that perhaps some of you haven't gotten. Coming from the Netherlands, the Amsterdam Court of Appeals ruled today that Universal Music does not have to pay 3 Dutch singer-songwriters more percentage of money for streaming, and it was 3 fairly well-known Dutch singers who went to court, and it was closely followed. Of course, in the Netherlands, they wanted a 50% earnings. They demanded half the earnings because they said Universal sold them out to Spotify, Apple Music, etc., YouTube. And the High Court in Amsterdam ruled, no, this wasn't true. It wasn't part of their original contract, and that Universal had to invest significantly in order to get these 3 artists' music out there. It's a very interesting case, and it's not clear. I'm in touch with one of the lawyers for the artists, and he says it's not clear if they're going to go on appeal. And I thought I would share this information.
Thank you very much for that. We'll have to consider that and see where that leaves us. Any other points? I know that, Beat.
Obviously, the fair share of performers is extremely important, but I would like to come to another point now. A little pause in the labels bashing. And that is the question that Christoph has raised. Christoph was his name, yes. Christoph, in his panel, the visibility of local music, the discoverability of local music, or if you want, the diversity of cultural expressions. And then we get to the point where we have situations in small countries like myself, I come from Switzerland, where we know that Spotify doesn't have a single employee. And there is nobody making a curated playlist of Swiss music in Switzerland. Somebody is sitting in Germany trying to do it. That's what we know. Maybe this is wrong, but that's what we know. Of course, this leads to a situation where the local production, the local musicians, the future of the music of a small country in this case, doesn't really have a good start, doesn't have a good standing. Because, as we know, streaming makes up 70–80% of the market. If you're not visible, if you're not there, you don't exist. And you don't have a career, regardless of how many zeros you have after the comma for a streaming pay, but you just don't exist. And so that's a major issue, and I believe it is an issue for many other countries, and it seems that the platforms are just following a business logic there and just serving the big markets because it's more interesting, obviously, economically. Maybe you have to say something to this, Senior.
Interesting point, yes. Xenia, would you like to respond? So are the created lists actually working against cultural diversity?
Thank you, Beat, for raising this. I think Switzerland is a fascinating country, and as many of you probably know, it has at least 4 official languages: French, German, Italian, and also Romansk, if I remember correctly and pronounce it correctly. And in addition to that, it has actually a large population of expats who listen to their local music. So yes, Spotify operates in 184 markets. We wish we were at the place where we could put a dedicated editor in every single of those markets physically on the ground, but that's not the case. So what we do for the Swiss market is that we have editors who curate for Switzerland the local playlists in all of those 4 languages. But they are based outside of Switzerland. And this is also a little bit of a reflection of how the careers of Swiss performers develop. Fairly often, if you're a German performing artist, you might start off in Switzerland, but you might want to move to a bigger market, which geographically is Germany. So we see a lot of that kind of transition in artist careers. So being based in Berlin to to curate is not necessarily a disadvantage. But what we do always strive is to have an offer and a service that is culturally relevant to consumers everywhere where we operate. So we certainly want to satisfy that desire for diversity and for discovery of music, including local music. What we do have concerns about is attempts to achieve through legislative means certain results which might interfere with the consumer choice, because that is not the way in which consumers will be happy to continue paying for a service. So that's something that is very important to recognize. But yes, culturally relevant product is absolutely fundamental.
Thank you for that. Maybe you two can talk about that later. It's quite an issue. Any other points from the floor at the moment? Can I ask one question? In the last panel, I think it was Paul that was saying that, and we talked about the collective bargaining agreement in France and what the AFM have done in the US to get payments for streaming. But then Tino said that they're looking for a legislative solution. They're looking for something in the law. And I think you said, Paul, that we can't do it by collective bargaining. We can't do it by contract. And it has to be the legislators that intervene. There's a reticence, and it's difficult. And Marcus de Souza, when he was telling us that we wanted this item to be on the permanent agenda of the SCCR, or WIPO, and we've had difficulty with that. And it's still any other matters. It's just mopped up at the end. And certain of us that have been to the WIPO meetings know that if we're lucky, we maybe get a minute. More likely 30 seconds or nothing at all. At the last meeting, they didn't let the NGOs speak. And I think Johan was particularly frustrated by that. And we've got lots to say. And until we get this as a permanent agenda item, it's going to be very difficult to get individual states to move. Now, I've just seen this afternoon, I think WIPO published a proposal for Indonesia for an instrument, which is interesting. And at first reading, we would support it. But you know how long this takes. I mean, the lobby for performers' rights started, and the research I'd done, in the sort of mid to late 1920s. Rome Convention, 1961, you know, and then implementation in various countries. In my country, in the UK, wasn't implemented till 1996. You know, that's a long wait for a lot of performers if we're going to do it the way through international treaties. And the experience, as the UK, as Naomi said, and we've heard, is the governments don't want to interfere. At WIPO, we've heard the US representative saying that everything should be left to the market. We shouldn't have treaties dealing with this. It should be market forces that deal with this. So we have a real issue. And unless the industry can get around the table, I'm looking at Lowry now, and come up with creative solutions for this, we're going to have a problem. And it's going to get worse. It's not going to get better. But we'll certainly carry on lobbying at WIPO. We do play the long game. Lowry, did you want to respond?
Sure. Thanks, John. I mean, look, I mean, you know probably better than anyone, our door is open, and we definitely believe that you know, discussions within the industry is better than legislative intervention, apart from setting a robust copyright framework in place. And as have been discussed, you know, there are examples of industry negotiations, you know, from France, Netherlands, UK, and I understand, Dave and Naomi, you may not be 100% satisfied, but nobody is. That's the nature of negotiations. And I'm a little bit concerned that you know, if you only want the ideal solution and refuse fair compromises, then it's obviously a little bit difficult to negotiate. But as said, as an industry, you know, door is open, and we have had these discussions. And I would go back to one point, and I stand by my claim that mere remuneration rights destroy value. And I say that because I have 35 years of experience in negotiating with users, where we negotiate on the basis of a mere remuneration right, no ability to say no if the other side does not want to pay fair value for our rights. And that this is what we get. Commercial radio, including music radio, global average pays around 2% of their income to artists, performers, and labels together. We've discussed this, and I do believe that is something we need to continue to discuss in order to fight for the value of our music. So my point is this: we all agree that artists need to be fairly remunerated and the value of music has to be respected. We disagree what is the best way to ensure that. And all the data we have from the markets is that things are getting better.
Thank you, Larry. One thing that I will agree with is the music is undervalued, and we know we've spoken in the past about a joint campaign. We do work with the record industry, and we've worked successfully in the past with the industry on issues like this. And I think this is an issue that we should work with to actually increase the value of music. Philippe.
Je remercie beaucoup Laurie pour cette intervention. Mais d'accord, la porte est ouverte. D'accord, on peut négocier. En France, on le fait. Mais il faut discuter de tout. Comment on peut négocier si on ne discute pas de tout? Quels sont les deals entre les labels et les plateformes? Quels sont les deals entre les majors et les plateformes? Il y a un chiffre que j'ai critiqué, mais qui a été publié il y a un mois pour la première fois. Ça n'avait jamais été publié, la part qui, selon les majors, va aux artistes. Donc, certes, la porte est ouverte et vous nous invitez à négocier, mais il faut tout dire. Parce que si vous ne dites pas tout, on ne peut pas négocier sérieusement. Je pense que vous pouvez le comprendre, mais quoi qu'il en soit, par rapport à cette proposition, je dis banco.
Thank you, Philip. So it's the notorious NDAs maybe we're talking about now. We won't go there. That's a whole other topic. Paloma wants to come out. Okay, yeah. And then, yeah. So we've got the microphone. Maybe Larry first to respond to that point.
I just reminded that there are serious limits that what can be discussed, because remember, all the labels are also competitors. For them to disclose their commercial deals with the streamers would be a serious breach of the applicable competition law. So we are open. Transparency is important. No issue with that. Absolutely agreed. But there are certain limits. We didn't invent them. That's the societal norms.
Thank you, Larry. Paloma.
Thank you. On this question of value, for me, it's worth to report on what has been published by local IFPI, Pro Musicae in Spain, regarding the growing of the music market. We have appreciated that in the last years, have figures from 22, 23, 24, the physical market has grown less than the digital market, and the biggest revenue of biggest source of revenue, despite of collecting intellectual property rights, has been the digital market. So the streaming market is growing despite of this remuneration rights established in Spain. So it is not accurate. It is directly a mistake to say that this is is constituting a problem from the market in Spain. It's the contrary. Even if the market, those rights are implemented, even if the intellectual property rights are paid, the market continues to grow. So the value is, of course, in the performance also. Thank you.
Thank you. And the value is growing year on year, as you say. Thank you for that. Yes, please, Laurent.
Yes. About transparency, I'd like to ask you what means do you have today to identify correctly all the performers comprising non-feature performers? You know, because the code of the phonograms doesn't give this information. And to have transparency, the first step is to be able to identify correctly all the performers. I don't know if we have standards today, DDEX or and so on, I don't know exactly, But I'd like to hear you about that, please.
Before Larry responds, I'll take another question for you, and that'll be the final one for this session. So, colleague here.
Thank you very much, Mr. President. My name is Tassos Katopodis, and I am General Secretary of Hellenic Entertainment Federation. The cases of Space, Korea, Brazil are very, very important, and we have to see these cases. We are performers, but I think that the most important is to change the laws all over the world about neighbor rights. We want more for the artists, so we have to succeed, less for the producers, discography companies. Here in Greece, the most amount from the neighbor rights go to the discography companies, 50%, and the musicians take 25%, and the singers take 25%. This is unfair. We think that all this must change. Who take the decisions? The governments. So, if we have always discussions, we have no results. So we have to press the governments for these changes. Here in Greece, we think that the discography companies must take 33 and something percent, the musicians 33 and something percent, and the the singers must take the same 33 and something percent. If we are always in discussions and we have no results, so I think that all of us must go to the other road to press the government to change the laws. Thank you very much.
Thank you. Thank you for that. Larry, do you want to respond on the data issue, and then I'll give you the final word with that.
As you know, the situation is different between the non-featured and the featured artists. Featured artists have their agreements, and there are very detailed accounting provisions, including an audit provision. As regards to the unfeatured, non-featured session musicians, as a rule, they are paid a session fee with no royalties. There may be some exchange sort of changes to, or exceptions to this rule, but that also means because there are no royalty provisions, obligations, in particular in the past, the lineups, you're absolutely right, have not always been, you know, if you will, fully featured. The situation has changed in the recent years, partly also because of the streaming market and the consumers wanting to have more information as to, you know, who's played on what, which also means that at least when I listen to music and I look at the credits on my preferred streaming service, which I'm not going to mention here, you actually have a lot more information on the lineups and who played the drums on recordings in '72 and so forth. So a lot to be done there. Labels don't have all the answers. And I think it's an area where, you know, CMOs, labels can work together. I would hope that the performers CMOs would have that information also in Europe, obviously, because of the term directive, and for broadcast and public performance distributions, the full lineups are necessary.
Thank you for that, Larry. And yes, there has been progress, and there has been progress in VRDB. I'm sorry, Roberto, I've been given the signal to wind up. Maybe tomorrow we can bring the court. So that was a great discussion. Thank you for that. You know, during the course, maybe tomorrow we'll get another little session to have some supplementary questions. Thank you.